Chief Justice, and may it please the Court. My name is Monica Haddad, and I, along with my co-counsel, Alex Landback, represent the Respondent, the United States, in the appeal before this Court. The Respondent respectfully requests that this Court affirm the judgment of the 14th Circuit Court of Appeals because its interpretation of the term negligently in the context of Section 1319 C1A of the Clean Water Act is the civil standard of negligence, and additionally, that the term corruptly persuades in the witness tampering statute, Section 1512B3, does mean motivated by an improper purpose. I will be addressing the Clean Water Act, and my co-counsel will address witness tampering. The 14th Circuit's interpretation of negligently in the context of 1319 C1A was correct for two reasons. First, the Court correctly followed well-established principles of statutory interpretation set out by this Court, and second, the Clean Water Act is a public welfare statute, which is consistent with a lower mens rea required to convict. Turning to the first point of statutory interpretation, the Court must first look to the plain language of the statute when Congress has failed to indicate a definition for a key term within the statute. And the language of Section 1319 C1A states that any person who negligently violates Section 1311 shall be punished by a fine of not less than $2,500 nor more than $25,000 per day of violation, or by imprisonment for not more than 1 year or both.
How do you address the argument that there is no express instruction from Congress in the statute reducing or doing away with a mens rea requirement?
Your Honor, in this case, there actually are several mens rea options within the criminal penalties section, C1A. We have negligently, we have knowingly, and we have knowing endangerment. These are all mens rea that have been recognized by this Court. In this case, it's not a strict liability offense, so there is some language there Congress has provided. And this Court has always granted deference to Congress that where it includes particular terms, the common law meaning associated with legal terms are also follow along with it.
But if you're saying that we should look at the plain meaning of the term here, how do you respond to the petitioner's argument that the word negligence exists within a criminal statute, therefore we should look at criminal negligence as opposed to civil negligence?
Your Honor, Congress has had multiple opportunities to go back and change the language if that is what they intended. If one looks to Section 1321 within the Clean Water Act, Congress did use the term gross negligence. Therefore, there is some indication from Congress that it is aware of the different mens rea that are possible for prosecution under this statute. Additionally, petitioner is wanting to read words into the statute that just are not there. Frankly, the short answer is Congress did not write the statute that way. Therefore, this Court should stick to the plain meaning, which in this case, the adoption of the term negligently does mean the failure to exercise the standard of care that a reasonable person would do in similar circumstances. Additionally, if this Court does look to the broader context of the statute overall, one would see that the inclusion of different levels of mens rea indicates that Congress did wish to punish different levels of culpability. In this case, offering opportunities for prosecutors to choose among a variety of mens rea, negligently, knowingly, and also knowing endangerment. Furthermore, the negligence standard is convenient in many instances when prosecutors can't pursue a charge under knowingly and offers another option to prosecute people who are culpable in a situation such as the Exxon Valdez spill, which was prosecuted using C1A.
You're not suggesting that we should ignore due process problems because it's convenient for the government to make a case, are you?
No, Your Honor, of course not. However, Congress has included a mens rea, and additionally, this goes to the public welfare argument that this statute is a public welfare statute. Therefore, ordinary negligence has been held to be sufficient to convict in these instances. In United States v. Ballin, this Court stated that ordinary negligence was okay. Therefore, we have the Court going back all the way to 1922 stating that ordinary negligence in the context of protecting society at large is acceptable. Here we have the Clean Water Act designed to protect American waterways. The fact is that one defendant versus society as a whole goes to the heart of what a public welfare statute is. And in this case, that is exactly what we have when there's a $1.25 billion loss as indicated on page 8 of the record, and also 23 lives were lost. This again goes to Mr. Millstone's argument that his due process rights were violated. It does not make sense when there's both a mens rea requirement which he's satisfied.
Isn't the problem with calling it a public welfare statute that the breadth of the punishment allowed serious fines up to $25,000 a day and a year in jail. Doesn't that take it outside the narrow purview of a public welfare statute?
Your Honor, the light penalty in this case, it is a misdemeanor charge. It is not a felony, which is one of the key things that this court stated in Staples, is looking to the severity of the punishment. In that case, a 10-year punishment for having a machine gun that turned into an automatic weapon was held to be too harsh a penalty to be public welfare. However, in this case, we have a 1-year possible maximum imprisonment, and in United States versus Freed, that was stated to be acceptable under a public welfare offense doctrine. Therefore, we already have case law from this court stating that 1 year is acceptable as a limit for public welfare statutes.
What about the $25,000 a day?
Your Honor, in this case, there was only 3 days where the chemicals were spilling into the water, therefore subjecting Mr. Millstone to a $75,000 penalty maximum. However, here we have a $1.25 billion loss, which is significantly outweighs the penalty to Mr. Millstone in this case.
Well, what's the basis for that comparison? I mean, $75,000 is more than most Americans make in a year. So what's the basis to saying that because the damage is so large, the penalty is just and it's not overbroad, and keeping it within the public welfare exception?
That goes to the nature of the public welfare exception, though, because in this case, it is still small a penalty in relation to the harm that society must endure due to this defendant's negligence in this case. As this court has stated in United States versus International Minerals Company, the notice requirement is not at issue here because one who stands in reasonable relation to a dangerous or obnoxious material is presumed to know the regulation. Mr. Millstone cannot hide behind the fact that he's merely an independent contractor providing a security service, didn't know the pedals were gonna stick or crash into a tank. Instead, he knew that he was specifically providing security to a 270-acre site with 1,200 employees at any time. He is presumed to know that that is exactly why he was hired, was to prevent this kind of spill, and it is indicated in the record that that was why he was hired.
But the standard you're asking us to put into place here would apply to other cases where, perhaps the outcomes wouldn't be nearly as significant, but yet the standard would still be the same. And how is that equitable?
Your Honor, the negligence is the main fact is that this statute includes a mens rea. Someone failing to exercise the standard of care means that they were in a position to prevent this kind of act. In this case, Mr. Millstone had the opportunity to stop the spill or take steps to prevent something like this happening, and he did not. That is sufficient to criminally convict when one looks at the consequences for society at large. Additionally, going back to the plain meaning of the statute, this court, Congress in 1972, when enacting the criminal penalties provision, one of the representatives on the floor wanted to call attention to his fellow representatives that the fact is that only simple negligence is required to convict under this provision, indicating, again, if this court feels it's necessary to go to legislative history, we have Congress's intent stating that simple negligence was what they were.
As a practical matter, isn't it a little difficult to tell a jury that we're going to ask you to the standard you have to apply as far as the burden of proof is beyond a reasonable doubt, but you have to apply beyond a reasonable doubt to a civil standard? Isn't, practically speaking, sending a mixed message to a jury and creates questionable results?
Well, if the burden of proof is that he exercised the failure to use due care, then that is only more proof that the jury was convinced, if they had to be convinced beyond a reasonable doubt, that they found his actions in relation to what the charges were based on. His negligence in hiring, supervising, and training these employees, and also selecting this vehicle.
But don't you run the risk when you ask the jury to apply a civil standard in a criminal proceeding of reducing, in their minds, the burden that the government has to meet?
Your Honor, unfortunately, Congress did enact the statute with the term negligently, finding it was important. This was the standard they wanted to be used. Again, going back to the public welfare nature of this statute, to protect the American public at large, maybe negligently is exactly a civil standard is what was needed, because it's when government steps in the interest of society at large, instead of possibly having petitioners say the tort system filing a civil suit would have been the more appropriate action. Instead, here we have the government stepping into that position and filing the action on behalf of the American public.
How do you respond to the petitioner's argument that this standard denies the defendant its right to due process?
Your Honor, there is no denial of due process in this case because, again, going back to international minerals, this court stated that where one stands in reasonable and responsible relation to obnoxious waste materials, he is presumed to be aware of the regulation. In this case, in international minerals, it was the transport of sulfuric acids. A trucking company cannot claim, no knowledge.
Well, we're not talking about a contractor who is preparing the chemicals or transporting the chemicals or handling them in any way. He signed up to provide security. He signed up to stand watch, to not come in contact. Arguably, the chemical company wished they hadn't come. We'd all wish they hadn't come in contact. So how is a security provider put on notice of the Clean Water Act that they may or may not have ever had any awareness of, but were there to provide security for?
Unfortunately, that's the nature of entering that kind of business. It is in the record, it indicates that Mr. Milstein only had his Securitech company up for 2 years. His largest contract was $85,000. Instead, he was presented with this opportunity, $8.5 million contract, 10 times larger than anything he ever had. And possibly he was tempted, didn't do his research. But here we have someone who does stand in responsible relation. That is specifically the language from international minerals. We have someone who was in a position to provide security to specifically prevent a spill. And in this
so
case,
would a food service provider on the chemical on the premises, they have something boil over and it somehow gets into the chemicals? I mean, would they be held to the same standard? Would they have the same level of notice? Would a
Catering truck.
Catering truck, that's a good example. With the U.S. Postal Service, a mail truck that somehow comes onto the premises, but they somehow lose control. My concern is that this level of notice of the Clean Water Act, I think that we can all feel comfortable applying that to the chemical company. But to people who don't have anything to do with the chemicals, who may not know, is that just purified water that's in those tanks? That we're holding them to such a strict legal standard is troubling.
Your Honor, it does seem harsh, but this is the choice that Congress made in enacting a statute that would protect the American public at large. Although it does seem harsh, it is a negligence standard. Someone did fail to exercise due care. In this case, it could have been someone driving onto the premises. Unfortunately, accidents happen, but the deterrent effect of the Clean Water Act is once people know about the consequences of what will happen when contamination flows into any kind of waterway in the United States, this will be the consequences. And unfortunately, although it may seem harsh to some people, this is the way that it must be to protect the American public at large. Additionally, persuasive is the fact that the 9th and 10th Circuit Courts of Appeal have adopted the negligence standard to be one of civil negligence. And in United States versus Haddad, the 9th Circuit, confronted with very similar facts to this case, a supervisor working on a project along a railroad track was held under the negligence provision of the statute when he failed to adequately protect an oil pipeline that ran along the project where he was working. Instead, one of his employees, it wasn't him directly, negligently operated machinery and caused a rupture in the pipeline, emptying oil into a river in Alaska. In that case, defendant was convicted under that statute, and the court also determined that the Clean Water Act was a public welfare statute. Therefore, this court can look to the 9th Circuit, also look to the 10th Circuit, which in United States versus Ortiz in 2005 followed the Haddad reasoning, again recognizing the protection of the American waterways as key to the provision of this statute. And for all these reasons, Respondent respectfully requests that this court affirm the judgment of